Question 1. In a multinational corporation, an in-house counsel discovers senior management directed the billing team to categorize legal services under corporate advisory instead of regulatory compliance to obscure spending from the board and internal auditors. What are the ethical and compliance implications? A. Counsel must refile financial statements under SOX and Dodd-Frank for misreporting. B. Categorizing services for internal convenience is permissible under attorney-client privilege. C. Counsel must escalate under Model Rule 1.13, remediate misclassification, and consider self-reporting depending on severity. D. Counsel should wait until the next audit cycle to raise concerns. Correct answer. C. Counsel must escalate under Model Rule 1.13, remediate misclassification, and consider self-reporting depending on severity. Explanation. Under Model Rule 1.13, a lawyer for an organization must report up the ladder if they know of wrongdoing. Misclassification of legal spend to evade internal oversight may constitute financial misconduct or falsification. Counsel should escalate to the board or audit committee, ensure remediation, and if unresolved, consider reporting to appropriate authorities. Immediate reporting reflects professional and fiduciary duty, whereas delaying risks ethics or SOX violations. Question 2. During an internal investigation, how should a legal team preserve privileged documents while complying with discovery obligations and minimizing waiver risks? A. Search all employee emails and produce everything to avoid suspicion. B. Implement a privilege log, segregate sensitive documents with metadata markers, and limit disclosure to materials strictly responsive and not privileged. C. Provide a single bundle of redacted documents without logs. D. Delete suspicious documents after the investigation to prevent leaks. Correct answer. B. Implement a privilege log, segregate sensitive documents with metadata markers, and limit disclosure to materials strictly responsive and not privileged. Explanation. To preserve privilege during internal investigations and potential litigation, teams should use privilege logs to delineate documents withheld due to legal advice. Marking documents and employing clawback agreements minimize inadvertent waiver. Overproducing or destroying documents violates ethical and legal obligations, e.g., Rule 3.4 and spoliation rules. Question 3. Mr. Patel, General Counsel at a tech startup, learns that customer support teams installed remote monitoring software on employees' laptops to troubleshoot. However, this software captures keystrokes, including personal credentials and private messages. What should Mr. Patel do first? A. Issue a company-wide order to uninstall all monitoring without exception. B. Conduct a data mapping review under GDPR/CCPA. Immediately notify employees, restrict data in the software, update policies, and document legal basis for any retention. C. Advise employees not to use personal email on devices without policy changes. D. Ignore the issue unless there's a data breach. Correct answer. B. Conduct a data mapping review under GDPR/CCPA. Immediately notify employees, restrict data in the software, update policies, and document legal basis for any retention. Explanation. Remote monitoring with keystroke logging likely captures personal data, triggering privacy regulations like GDPR and CCPA. Mr. Patel must assess scope, notify staff if required, and ensure lawful basis, e.g., legitimate interest or consent. Policies must be updated, and data minimization principles applied. Ignoring or reactive deletion could lead to noncompliance or breaches of employee privacy rights. Taking deliberate, compliant action is essential. Question 4. An internal audit identifies a pattern of unreported gifts to third-party government officials by procurement staff. What is the recommended compliance response? A. Retroactively record the payments as miscellaneous fees in year-end financial statements. B. Initiate an internal investigation with documentation, report through compliance channels, self-report as appropriate, update internal controls, and conduct targeted anti-corruption training. C. Advise procurement staff to make gifts under $25 to avoid regulation. D. Transfer procurement decision-making to an offshore affiliate to obscure oversight. Correct answer. B. Initiate an internal investigation with documentation, report through compliance channels, self-report as appropriate, update internal controls, and conduct targeted anti-corruption training. Explanation. Gifts to officials implicate anti-bribery laws like FCPA and UK Bribery Act. Ethical compliance requires immediate internal review, remediation, possibly voluntary self-disclosure to authorities e.g. DOJ, and reinforcement of gift policies and training. Option A is deceitful. C. Ignores thresholds and oversight. And D. Perpetuates risks. A robust response is essential for compliance. Question 5. During a data breach, legal counsel discovers backup tapes containing sensitive client data were stored off-site with a service provider who is not under a binding data processing agreement. What must counsel ensure? A. Immediate deletion of all tapes to minimize exposure. B. Execution of a data processing agreement with the provider. Notification to affected individuals' regulators under GDPR CCPA. Risk-based forensic investigation, and future encryption of backups. C. Encryption only upon client's written request. D. That legal privilege prevents disclosure obligations. Correct answer. B. Execution of a data processing agreement with the provider, notification to affected individuals' regulators under GDPR CCPA, risk-based forensic investigation, and future encryption of backups. Explanation. Under GDPR Article 28 and analogous laws, companies must use formal data processing agreements with third parties handling personal data. Counsel must act swiftly to secure contracts, assess breach impact, notify affected parties and authorities, and ensure future encryption. Deleting tapes without addressing root compliance could signal negligent handling. Privilege does not override breach reporting obligations. Question 6. Ms. Nguyen, Chief Compliance Officer, uncovers evidence that financial controllers manipulated accounting entries to meet quarterly targets. She also discovers a set of communications evidencing senior management knowledge. What is her appropriate course of action? A. Pause investigation until next board meeting. B. Activate her up-the-ladder reporting obligation under Model Rule 1.13. B. Escalate to Board Audit Committee, recommend external investigation, and counsel self-reporting to SEC or other authorities. C. Inform management to correct books privately. D. Allow management to restate quarterly numbers without escalation. Correct answer. B. Activate her up-the-ladder reporting obligation under Model Rule 1.13. B. Escalate to Board Audit Committee, recommend external investigation, and counsel self-reporting to SEC or other authorities. Explanation. When internal controls are materially misstated with management knowledge, the CCO must escalate within the organization under ethical rules, and if no action follows, may have to report externally. This ensures integrity, protects investors, and aligns with Sarbanes-Oxley and SEC expectations for whistleblowers. Question 7. What ethical standards should counsel observe when using AI-powered document review tools for privileged materials? A. Inputting all documents, including privileged emails, without any safeguards. B. Vetting AI vendors' data retention policies, ensuring data is securely handled, and restricting AI to non-sensitive text via secure environment. C. Sharing client work product within the AI community to train algorithms. D. Providing unrestricted AI access to expedite speed. Correct answer. B. Vetting AI vendors' data retention policies, ensuring data is securely handled, and restricting AI to non-sensitive text via secure environment. Explanation. Use of AI tools in legal work demands careful vetting under ABA opinions regarding confidentiality and technology competence. Model Rule 1.1. Privileged or sensitive files must not be exposed without secure controls and agreements. Open usage risks breach of privilege and ethical duty. Question 8. A whistleblower submits an anonymous tip via your hotline alleging discrimination by a senior manager. What principle governs the initial investigation? A. Investigators must identify the tipster before any action. B. Maintain confidentiality, ensure impartiality, document findings objectively, and protect against retaliation, even if investigations are anonymous. C. Immediately terminate the accused to avoid board liability. D. Require named affidavit before proceeding. Correct answer. B. Maintain confidentiality, ensure impartiality, document findings objectively, and protect against retaliation, even if investigations are anonymous. Explanation. Ethical handling of whistleblower claims requires confidentiality, non-retaliation, impartial investigation, and thorough documentation. Anonymity is allowed, and action cannot wait for tipster identity. Internal policy and regulations like SOX and EU Whistleblower Directive mandate these protections. Question 9. Mr. Kim, Data Privacy Counsel for a healthcare firm, learns that third-party AI software is automatically processing patient faces from surveillance videos for security. He is concerned this violates GDPR biometric data requirements. What is his best first step? A. Deactivate surveillance immediately because of any risk. B. Conduct a Data Protection Impact Assessment (DPIA) for biometric data, confirm lawful basis, likely explicit consent, implement enhanced security and update privacy notices. C. Accept it as falling under corporate security, legitimate interest. D. Outsource surveillance operations to an external vendor to shift liability. Correct answer. B. Conduct a Data Protection Impact Assessment (DPIA) for biometric data, confirm lawful basis, likely explicit consent, implement enhanced security and update privacy notices. Explanation. Biometric data is a special category under GDPR, requiring careful lawful processing. A DPIA determines risk, security safeguards, and compliance with Articles 9 and 35. Consent or other strong legal basis is required. Disabling surveillance or shifting responsibility without procedure is neither compliant nor appropriately rigorous. Question 10. Under ABA Model Rule 5.4, which practice presents an unauthorized fee-sharing risk for law firms? A. Paying referral fees to non-lawyer business introducers without appropriate disclosures or client consent. B. Offering discounted rates to senior citizens. C. Splitting fees between firms in different states with full client disclosure. D. Providing pro bono services. Correct answer. A. Paying referral fees to non-lawyer business introducers without appropriate disclosures or client consent. Explanation. Model Rule 5.4 prohibits fee sharing with non-lawyers unless structured as part of a marketing agreement compliant with jurisdictional rules. It protects professional independence and client interests. Discounted or pro bono services, B, D, are ethically sound. Fee splitting with lawyers in other states, C, is allowed with disclosure and agreement. Question 11. What ethical obligation does a supervising attorney have for work delegated to non-lawyer assistants? A. None. Supervision is voluntary. B. Ensure assistants perform tasks competently, review their work, and take responsibility for errors under Rule 5.3. C. Delegate billing responsibility without oversight. D. Sign their names to final documents without reading them. Correct answer. B. Ensure assistants perform tasks competently, review their work, and take responsibility for errors under Rule 5.3. Explanation. Model Rule 5.3 requires attorneys to supervise non-lawyers to ensure ethical compliance, confidentiality, and proper qualification. They must train, delegate appropriately, and be accountable for their team's work. Ignoring oversight C, D, or misrepresentation, A, risks malpractice and ethical violation. Question 12. Ms. Chen, partner at an international firm, is approached to advise a foreign state-owned company under U.S. jurisdiction about a potential acquisition. The firm advises compliance with the FCPA. However, local subsidiaries bribe officials as standard practice. What should Ms. Chen do? A. Proceed with advice. Local customs justify payments. B. Decline representation or withdraw. Escalate concerns under FCPA and OECD anti-bribery obligations. C. Advise local subsidiaries they operate independently to shield U.S. liability. D. Offer to funnel payments through consultant fees to obscure purpose. Correct answer. B. Decline representation or withdraw. Escalate concerns under FCPA and OECD anti-bribery obligations. Explanation. FCPA prohibits bribery of foreign officials by U.S. persons or entities. Lawyers must advise against and refuse participation in corrupt practices. Local customs don't excuse violations under Section 30A and the OECD Convention. Escalation and withdrawal preserve ethical integrity and compliance. Question 13. How should a lawyer manage trust accounts under Rule 1.15 regarding client funds? A. Commingle client and firm funds if used for accounting convenience. B. Keep client funds in a separate interest-bearing IOLTA or trust account. Maintain detailed ledgers and reconcile monthly. C. Transfer client funds into an attorney's investment portfolio. D. Use escrowed funds for overhead if client balance is low. Correct answer. B. Keep client funds in a separate interest-bearing IOLTA or trust account. Maintain detailed ledgers and reconcile monthly. Explanation. Rule 1.15 mandates strict segregation of client funds, accurate records, and reconciliations to prevent misappropriation. Interest-bearing IOLTA accounts benefit public programs. Options A, C, and D violate trust accounting requirements and pose ethical and disciplinary risks. Question 14. A law firm contracts with a cloud provider for case data storage. What must the firm ensure to meet confidentiality obligations under Rule 1.6? A. Require that the provider be overseas to reduce subpoena risk. B. Use service providers bound by confidentiality agreements, secure encryption and audit controls, and verify they won't claim privilege over client data. C. Share data freely with third-party vendors for AI analytics without disclosure. D. Store only metadata in the cloud. Keep documents locally. Correct answer. B. Use service providers bound by confidentiality agreements, secure encryption and audit controls, and verify they won't claim privilege over client data. Explanation. Lawyers must secure client confidentiality when outsourcing to third parties, Rule 1.6 CMT. 18. This includes contractual confidentiality clauses, appropriate technical safeguards, and control over privileged information. Options A and C risk unauthorized disclosure. D minimizes risk but avoids issue, not ideal. Question 15. Mr. Alvarez, compliance counsel at a multinational firm, learns a regional affiliate is selling to sanctioned individuals listed by OFAC. Contracts use generic wording to avoid direct references. What should Alvarez do? A. Ignore the affiliate's disclaimers. B. Immediately escalate. Recommend suspension or termination of contracts. Self-report to OFAC and implement enhanced sanctions, training, and controls. C. Reword the contract disclaimers to avoid liability. D. Ask affiliate to bill customers offshore to distance from sanctions. Correct answer. B. Immediately escalate. Recommend suspension or termination of contracts. Self-report to OFAC and implement enhanced sanctions, training, and controls. Explanation. Dealing with sanctioned parties violates OFAC regulations. Counsel must escalate, stop prohibited transactions, report self-disclosure, and strengthen corporate sanctions compliance. Generic contract wording doesn't provide safe harbor. Avoiding or ignoring the issue is not defensible. Question 16. Under EU Whistleblower Directive, what must employers provide in internal reporting systems? A. Only an email address with no anonymity. B. Confidential and anonymous reporting channels, acknowledgement of receipt, protection from retaliation, and timely feedback on investigation steps. C. Public disclosure of whistleblower identity. D. Only management-level reporting without confidentiality. Correct answer. B. Confidential and anonymous reporting channels, acknowledgement of receipt, protection from retaliation, and timely feedback on investigation steps. Explanation. The EU directive requires secure, confidential, and anonymous reporting systems, protections for whistleblowers, and procedural transparency. Employers must respond within specified timelines. Options A, C, and D fail to meet minimum legal protections and may render systems non-compliant. Question 17. When conducting cross-border internal investigations, which ethical issue is most significant? A. Deciding whether to bill in USD or EUR. B. Reconciling conflicting local privacy data laws, e.g., GDPR, China CSL, while preserving privilege and attorney-client privilege. C. Scheduling video conferences during different time zones. D. Choosing which language to take deposition in. Correct answer. B. Reconciling conflicting local privacy data laws, e.g., GDPR, China CSL, while preserving privilege and attorney-client privilege. Explanation. Cross-border investigations trigger laws like GDPR, which may restrict data transfers and employee consent requirements and local privilege rules. Counsel must balance confidentiality, privilege, and compliance obligations. Options A, C, and D are logistical, not ethical or compliance-centered. Question 18. Ms. Roberts, lead counsel in a multi-district securities fraud lawsuit, is asked by co-counsel to withhold maintenance logs as they are not relevant. Some logs contain privileged communications. How should she proceed? A. Fully produce the logs to maintain trust with co-counsel. B. Conduct a privilege review, prepare and share a privilege log, and negotiate redactions under protective order before production. C. Provide an informal summary without documenting formal production. D. Refuse to cooperate with co-counsel. Correct answer. B. Conduct a privilege review, prepare and share a privilege log, and negotiate redactions under protective order before production. Explanation. Under Rule 26b, 5 and privilege norms, Ms. Roberts must review documents for privilege, log withheld items, and negotiate protective redactions. She may share logs without waiving privilege. Summary C or refusing cooperation D could result in sanctions. Full unvetted production A risks privilege waiver. Question 19. What best practice ensures attorney-client privilege is maintained during e-discovery? A. Turn over all suspicious emails to avoid accusations. B. Implement litigation hold notices, isolate systems, use privilege markers, and involve IT and ESI experts early. C. Delete email threads with multiple recipients once case is filed. D. Publish a disclaimer that all communications are privileged. Correct answer. B. Implement litigation hold notices, isolate systems, use privilege markers, and involve IT and ESI experts early. Explanation. Privilege preservation requires legal hold implementation, IT-driven data isolation, privilege tagging, and professional handling by discovery experts. Deletion C or blanket claims D are legally insufficient. Providing all emails A may waive privilege. Early action safeguards privilege and attorney obligations. Question 20. Under Rule 3.3, regarding candor to the tribunal, a lawyer discovers after filing that the clerk's transcript misquotes a key admission. What must the lawyer do? A. Ignore it. Clerks are responsible for errors. B. Promptly correct the record. Notify the court, opposing counsel, and submit amended filings if necessary. C. Wait until another party raises the issue. D. Withdraw without correcting the record. Correct answer. B. Promptly correct the record, notify the court, opposing counsel, and submit amended filings if necessary. Explanation. Rule 3.3 requires disclosure of any mistake or omission that makes filings misleading. The lawyer must correct the record promptly, regardless of who made the error. Waiting C or ignoring A would breach duty of candor. Withdrawal D does not remedy the false record. Question 21. Mr. Davis, external counsel, is subpoenaed for internal investigation work product and privileged communications regarding an antitrust investigation. The company has privilege windows with staff involved in case prep. What should he do? A. Comply immediately to avoid contempt. B. File a motion to quash or limit, asserting privilege and work product protection in compliance with local rules. C. Produce everything but ask for immunity. D. Ignore the subpoena. Correct answer. B. File a motion to quash or limit, asserting privilege and work product protection in compliance with local rules. Explanation. Counsel must timely challenge subpoenas seeking privileged documents. Protective rules allow motions to quash or limit production. Compliance without asserting privilege risks waiver. Ignoring the subpoena risks contempt. Question 22. Under FCPA, what due diligence step is essential when onboarding a sales agent in a high-corruption country? A. Accepting references from colleagues only. B. Comprehensive third-party diligence, including background checks, corruption risk profiling, contract anti-bribery clauses, ongoing monitoring, and triggering termination for misconduct. C. Paying highest commission upfront to reduce incentive for bribery. D. Excluding the agent from finance to reduce risk. Correct answer. B. Comprehensive third-party diligence, including background checks, corruption risk profiling, contract anti-bribery clauses, ongoing monitoring, and triggering termination for misconduct. Explanation. FCPA enforcement places liability on U.S. companies for third-party wrongdoing. Diligence, robust controls, and contractual safeguards are essential for compliance. Options A, C, and D are insufficient or counterproductive measures. Question 23. Which compliance program element is most critical for continuous improvement under ISO 30-7301? A. Optional annual lunch meetings. B. Regular monitoring, internal audits, feedback loops, KPI reviews, and timely corrective action. C. Publishing a code of ethics once. D. Outsourcing all training. Correct answer. B. Regular monitoring, internal audits, feedback loops, KPI reviews, and timely corrective action. Explanation. ISO 37301 requires an ongoing, metrics-driven approach to compliance management. Monitoring identifies issues, audits evaluate program effectiveness, and KPIs and correctives ensure the system evolves. Publishing a code only once C fails to embed compliance culture, and outsourcing D may disconnect from internal oversight. Question 24. Ms. Lee, GC at a multinational, learns that a non-U.S. affiliate bribed local officials. The affiliate now shares physical documents with U.S. auditors. What should she advise regarding privilege and compliance? A. Rely on foreign privilege law, no U.S. protections. B. Assess privilege under U.S. and local law. Assert privilege invasively if already in discovery, and conduct immediate FCPA remediation and voluntary disclosure. C. Instruct auditors to disregard bribery documents entirely. D. Shred documents to avoid detection. Correct answer. B. Assess privilege under U.S. and local law, assert privilege invasively if already in discovery, and conduct immediate FCPA remediation and voluntary disclosure. Explanation. Cross-border privilege requires dual analysis. Counsel must assert privilege if applicable. Meanwhile, FCPA remediation and voluntary disclosure support cooperation credit. Ignoring the bribery C or destroying evidence D are unethical and illegal. Foreign privilege alone, A, is insufficient in U.S. enforcement context. Question 25. What due diligence is recommended when implementing AI for compliance monitoring to avoid bias and privacy violations? A. No review needed once vendor is reputable. B. Test for data bias. Ensure algorithmic transparency. Comply with GDPR fairness principles. Document decision-making logic and retain ability to override AI recommendations. C. Deploy AI directly on raw employee communications. D. Exempt external data from review. Correct answer. B. Test for data bias. Ensure algorithmic transparency. Comply with GDPR fairness principles. Document decision-making logic and retain ability to override AI recommendations. Explanation. Ethical AI requires transparency, bias mitigation, accountability, and human oversight. GDPR's automated decision provisions and ethical technology guidelines call for these layers. Blind deployment, a CD, risks discriminatory outcomes and regulatory violations. Question 26. When transferring EU personal data to the U.S., which mechanism ensures lawful compliance under GDPR? A. Verbal assurance from a U.S. partner. B. Standard contractual clauses, SCCs, with tailored audits and supplemental measures, or binding corporate rules. C. Encrypting data during transfer only. D. Locating U.S. data center backups offshore. Correct answer. B. Standard contractual clauses, SCCs, with tailored audits and supplemental measures or binding corporate rules. Explanation. GDPR Article 46 permits data transfer using SCCs or binding corporate rules as safeguards. Data encryption alone, C, is insufficient. Verbal assurances, A, or geographic workarounds, D, fail to meet data transfer obligations. Question 27. Mr. Santos, outside counsel on a multi-jurisdictional merger, learns that a due diligence report containing attorney analysis and crime risk has been circulated to third-party advisors without privilege markings. What should he do? A. Ignore the situation. Privilege is inherent. B. Conduct a prompt clawback. Notify recipients. Mark documents privileged and assess waiver risk under local laws. C. Share the document widely to dilute its sensitivity. D. Revise future reports to exclude legal analysis entirely. Correct answer. B. Conduct a prompt clawback, notify recipients, mark documents privileged, and assess waiver risk under local laws. Explanation. Under Rule 26b, 5b, inadvertent privilege disclosure can be remedied by clawback. Counsel should notify recipients to return or destroy copies. Failing to act can waive privilege. Diluting or ignoring the issue, a CD, is poor practice. Question 28. Under Rule 4.4 Respect for rights of third parties, what should a lawyer do upon receiving accidentally sent privileged opponent communications? A. Read them in full to better prepare strategy. B. Notify counsel immediately. Refrain from reviewing further and await permission. C. Use selective excerpts to undermine the opposing side. D. Hide the documents in subfolders. Correct answer. B. Notify counsel immediately. Refrain from reviewing further and await permission. Explanation. Rule B mandates that lawyers who receive inadvertently sent documents notify opposing counsel and stop use. Reviewing or using them violates professional responsibility. Options A, C, and D conflict with the duty to preserve fairness. Question 29. What is the most critical ethical consideration when an attorney receives a personal gift from a current government employee? A. Adding the gift to the law firm's holiday drive. B. Assessing whether the gift creates a conflict of interest or violates government gift rules, disclosing and possibly returning it. C. Accepting the gift if under $100. D. Publicizing the gift on the firm's social media. Correct answer. B. Assessing whether the gift creates a conflict of interest or violates government gift rules, disclosing and possibly returning it. Explanation. Gifts from public officials can give rise to conflicts or breach ethics rules and government regulations. Attorneys must evaluate intent, value, and compliance, then act via disclosure or return. Arbitrary thresholds C or self-interest D are inappropriate. Question 30. Ms. Becker, senior litigation partner, is leading a discovery process and realizes a junior associate intentionally withheld adverse key documents to speed up the case. What must she ethically do? A. Direct the associate to redo discovery without disclosing misconduct. B. Investigate immediately. Inform the court through appropriate channels or file a corrected production, and report internally under firm standards. C. Fire the associate without disclosure. D. Ignore it, hoping it won't be found. Correct answer. B. Investigate immediately. Inform the court through appropriate channels or file a corrected production, and report internally under firm standards. Explanation. Under Rules 3.3, 3.4, and 8.4, withholding adverse information is unethical and may require disclosure or remedial action. Ms. Becker must act to correct the record, maintain integrity, and address misconduct through internal processes. Silence D or concealment A violates ethical duties and can lead to sanctions.